Welcome to Oliver Ellsworth Legacy Day. This has been proclaimed Legacy Day by our mayor, Nuchette Verblack, and a copy of the proclamation is over by our DAR sign. This is a signature America 250 event, and your hosts, Town of Windsor, Windsor Historical Society, and the Daughters of the American Revolution. I'm Betsy Ridgway. I am the regent of our local chapter here. So a little bit about the Daughters of the American Revolution. We're a national organization founded in 1890, and the tenets are education, historic preservation, and patriotism. The Connecticut version of the national organization we call CTDAR. And we have 42 chapters and over 2,300 members. Our little local chapter here, the Abigail Wolcott Ellsworth, married to Oliver, has about 28 members, and we were founded in 1894. The Oliver Ellsworth Homestead was gifted to the Daughters of the American Revolution in 1903, and Matthies Hall was gifted to us in 1934. So we need to welcome our dignitaries. So just raise your hand when I call your name. We have our state rep, Jane Garapi. For the Daughters of the American Revolution, we're honored to have Madam State Regent Jolene Mullen. Our state historian, Sue Crombie. Our state chair for the Franco-American Committee, Pam Baldini. And our Oliver Ellsworth House Chair, Janet Ellsworth. Our co-hosts from the Windsor Historical Society, we have Carrie Taylor at the sign-in table, the Executive Director. And Heather Lodge, our Program Manager. For the Town of Windsor, we have James Finley, Economic Development Intern. And the man that made it all possible, our Director of Economic Development, Patrick McMahon, who will introduce our keynote speaker.
Thank you, Betsy. Good afternoon, everyone, and welcome. We appreciate you joining us for the continued celebration of America 250. Thank you to the Daughters of the American Revolution for hosting us today, and obviously the Historical Society for the support of this wonderful event. On Monday evening, the Mayor and Town Council proclaimed today as Oliver Ellsworth Legacy Day. A copy is on your tables. On Wednesday, we joined communities all across the nation to do a communal reading of the Declaration of Independence on the town green. Those who actually were part of the reading, raise your hands. So thank you for your participation in that. Yesterday, we had an absolutely wonderful community celebration of July 4th. We packed the town green. Fred's here. He was doing the foam pit. Way to go, Fred. Residents and visitors were able to enjoy live music, great food, and conversation. It was a great day. It's now my pleasure to introduce today's speaker, Michael Toth, author of The Founding Federalist, The Life of Oliver Ellsworth. I'm thrilled that Michael's summer travel plans made it possible for his visit to Windsor today. For Windsor, this program is especially meaningful. Oliver Ellsworth was not only one of the nation's founders and the third Chief Justice of the United States, he was one of our own. His vision helped shape the United States Constitution, establish the federal judiciary, and define the balance between our national and state governments, and continues to guide our nation today. As we commemorate America's 250th anniversary, it is fitting that we celebrate the extraordinary contributions of a Windsor resident whose influence reaches far beyond our community. Michael Toth has played an important role in bringing Ellsworth's remarkable story back into the national conversation and reminding us why his legacy still matters today. Please join me in welcoming Michael Toth.
Thank you so much, Patrick. Thanks to the Daughters of the American Revolution, to the Windsor Historical Society, to the Oliver Ellsworth Homestead, to Patrick and James and Carrie and everyone else who had a hand in making this event happen. And thank you to everyone for being here today. It's really an honor to celebrate this great day, Oliver Ellsworth Legacy Day. What a fitting tribute in exactly the right place to commemorate Oliver Ellsworth's memory. He's a man who unfortunately is not terribly well known, I think, outside of this area. But he really deserves to be. If we want to think about someone who may not have the name recognition of a Hamilton or a Madison or a Jefferson, but is actually influential in the building of American institutions, it's Oliver Ellsworth. So I'll spend a few minutes talking about what I see to be his most lasting contributions to the American form of government. But I invite questions all throughout. So I'll kind of be scanning the room. I'll talk for 20 or 30 minutes or so in terms of my prepared remarks, but don't feel like you have to wait until the end of the speech. Just at a high level, I'll be talking about Ellsworth as a framer, so that'll be the first section. His contributions to the U.S. Constitution, to the framing of our Constitution. And then I'll talk about Ellsworth's contributions as a legislator. We have a lawmaker here today, so we're familiar with that legislative process, the give and take of legislation. And Oliver Ellsworth is responsible for really one of the most lasting legislative achievements. And when I say lasting, I mean today. In 2026, the shape of the American judiciary is because of a law that he passed. So we'll talk about that. That'll be in the second section about Ellsworth as a lawmaker. And then we'll talk about Ellsworth as a judge. And he served, as Patrick mentioned, as the Chief Justice of the United States before John Marshall. So those are the three sections. And as I said, feel free, raise your hand at any point, and we can make this a conversation. Just very briefly, I just would like to say how I sort of came across Oliver Ellsworth, just a little bit of background on myself. I went to law school at the University of Virginia, and while I was in law school, I got a master's degree in history. So the University of Virginia had a joint program where you could get a JD, and you could also get a master's degree in history at the same time. And so I was kind of balancing legal studies with classes in history and American legal history and constitutional history. And so in the third year of law school, I was taking a history course, and we were reading a book called The Ideological Origins of the American Revolution. So this is a book whose author is Bernard Bailyn, is the name of the author, who's now passed away. But has anyone ever heard of Bernard Bailyn or this particular book? We got one hand back there. Bernard Bailyn was a longtime professor at Harvard University, and among his famous students is an American historian who tragically was just passed away, Gordon Wood, who was killed very tragically in a car accident in Providence, age 92. But if there's any fans of the movie Good Will Hunting, of course, there's a famous scene where Matt Damon in a bar talks about Gordon Wood and some of the great books of Gordon Wood. So Bernard Bailyn was a teacher of Gordon Wood, a teacher of many great students, a great American historian himself. And in his book, The Ideological Origins of the American Revolution, he talks about the fact that in the debate over the Constitution, which happened during the ratification period, there were a lot of, really tense exchanges about, the powers that this new executive branch was going to have. We didn't really have an executive, formally speaking, in the Articles of Confederation. This was something brand new for the American people. And a lot of really intense debates over the power of Congress right? Congress could now tax the American people. Prior to the Constitution, the Articles of Confederation could sort of ask the states to contribute to federal expenses. Now they could go directly to the American people for taxation and regulation. So, and there was the power to make treaties and on and on and on. There's a lot of debate about this. And then Bernard Bailyn says, there was less of a focus in the public debate about the judiciary, right? I'm a law student, right? As a law student, all you're really reading about is the judiciary. You're reading court cases from the judicial branch, federal or state. And so I was really, kind of amazed by this. And then he went on and he said, with one exception, Oliver Ellsworth, who was a delegate at the Constitutional Convention, who was from Connecticut, who went back to Connecticut after the Philadelphia Convention, and he wrote an essay, several essays, in defense of the Constitution, the landholder essays. And in one of the landholder essays, he talks about the new federal judiciary that's planned in the Constitution and what it will do and the role that it will play. And I was just amazed at all of this. I hadn't heard of Oliver Ellsworth before then. And so I was really, interested in this, and I thought, someone ought to write a book about Oliver Ellsworth. I mean, here's someone who was thinking about the judiciary, was writing about the judiciary, was sort of putting the judiciary in the context of this new plan of government. And the judiciary obviously is a very important part of the American government. We hear about, we read about every single day. And so I really thought, wow, he was sort of prophetic in a lot of ways about how the new plan of government was going to involve this judicial branch. So at the same time, I was sort of following some different trends in publishing, and I saw that a publishing house that I knew was doing a series of books on the lesser known founding fathers. And so I reached out to the publishing company. The publisher that I had is a man named Josiah Bunting, who was a very interesting man. He had 2 Bronze Stars from the Vietnam War. He had gone to VMI, and then he was a Rhodes Scholar, and then he went to Vietnam, and he was also a writer. He had written a book about Ulysses Grant. And so when I met up with Josiah and he agreed to commission the book, I was finishing up my 3rd year of law school. After law school, I served as a JAG officer, and I essentially started my active duty career about 6 months after finishing law school. And Josiah Bunting, I will always be grateful to him. He gave me a great piece of advice. He said, you don't want to be writing a book sitting on a footlocker in the Marine Corps. So try to get as much of it done in the next 6 months. So I wrote most of the book in the first 6 months after law school, and then kind of plodded through the back half of it when I was on active duty. And it came out right when I finished active duty in 2011. Just one final thing, just by way of introduction. So Bernard Bailyn, his book was the book that sort of introduced me to Oliver Ellsworth. In that 6-month period when I was writing the book, I was at this point writing the section about the Philadelphia Convention. And, obviously I had graduated law school at this time, and I knew, I got some feedback here. We hold these truths. So I knew sort of the outcome of the Constitutional Convention. I was aware of the constitutional text and sort of what came from the Constitutional Convention, the 3 branches of government. What I didn't realize until I started writing this book was how contingent everything was in my perspective. Like, it was not in my view, and I'll get to, sort of what was presented to me, but in my view, it was not foreordained that we were even going to have a constitution, that was going to be any agreement, and certainly not that the Constitution was going to look or take the form that it ultimately did. And so as I was reading the debates involving Ellsworth and Roger Sherman and James Madison and James Wilson and others who were there in Philadelphia during this historic period, I thought, well, this could have gone any number of different ways, this debate in Philadelphia in 1787. So I'm reading, the notes of the Constitutional Convention that James Madison took and other primary sources that go through this debate in Philadelphia in 1787. I'm doing that for much of the day, doing writing, and then in the evenings I would read a well-known American historian who has sort of written about the Constitution, just to get some further context. So I was reading a book by a historian named John Freeling, who's a very successful American academic historian, and he begins his book on the Constitution, and he says, there really was, maybe one or two important debates that the framers had to have, and it was obvious the conclusion they were going to come to in both. They were going to have some compromise on equal a portion of the Senate or one house of the legislature, and essentially the whole Constitutional Convention was basically an autopilot. I'm reading this, and this is a really well-known American historian, I'd read some of his books during my history masters, and I'm thinking, wow, this is very different from what I'm seeing, and I'm trying to finish this book, and I'm right in the middle of it. I don't know if anyone's had this experience before, where you're in the middle of a project, and you read someone or you hear someone who sort of says the opposite, and I was thinking, wow, am I really missing something? So that evening, Bernard Bailyn was giving a talk in New York City, and I went to his talk, and his talk was all about the ratification convention that the state of Massachusetts had. So Connecticut ratifies the Constitution. Oliver Ellsworth is a leader of that. Massachusetts has a separate state convention. They also ratify. And according to Bernard Bailyn, it was very touch and go whether Massachusetts was going to ratify. And if Massachusetts didn't ratify, that could have created a domino effect where the states wouldn't have ratified the plan that the framers came up with, et cetera, and so forth. So I went up to Bernard Bailyn after the talk, and I introduced myself. I told him something about Oliver Ellsworth, and I said, I'm writing this book, and I heard you sort of say that there was a lot of contingency about the Philadelphia Convention. I think the same, but I'm reading this book by Freeling, and he stops me right there, and he says, I know the book, I know John Freeling, and I disagree with it. And I thought, yes, okay. I drove back home over the George Washington Bridge, and I was like, I passed go, and I can collect 200. So in any case, obviously, with all of these historical issues, reasonable minds can disagree. So let me just say a few words on the topic at hand. And again, we'll start with Ellsworth, the framer. And I think the important point about Ellsworth, the framer, is when we think about the fathers of the Constitution, James Madison, Alexander Hamilton, these are the names that come up. And the way I put it in the book is that if we think about James Madison, he's very much the father of the Philadelphia Convention. So the idea of getting the delegates together in Philadelphia in the summer of 1787, that would not have happened, in my view, without James Madison. He felt, and Hamilton agreed, that the current plan of government that was in place at the time, the Articles of Confederation, was failing, and we needed to get delegates again together for a new convention to talk about a fix, a new plan of government, something, right? And that, I don't think, would have happened without James Madison. But if we actually look at the Constitution that came from the convention, Madison made 40 proposals for the Constitution, or 71 proposals. He lost over 40 of them. The Virginia delegates, which includes James Madison, brought a draft Constitution to the Philadelphia Convention. It had a Senate, which was appointed by the Congress. So the Congress, the House of Representatives, would have chosen the U.S. Senate. The Congress, in this Virginia plan of government, would have had the ability to pass a law to nullify any state law. Okay, so just think about that for a second. And again, this isn't meant to debate the merits of it. This is just a historical record, right? So this is what was in the Virginia plan. Obviously, that's not what we ended up with, right? So again, I think if you look at sort of the merits of the document, if you look at what came from it, you start to see that there's others in the convention who move our plan of government in a different direction. Alexander Hamilton, gave essentially one very long speech at the Philadelphia Convention. He proposed a president for life, a Senate for life. He proposed basically a power of the Congress to pass any law whatsoever. So essentially sort of plenary legislative power for the U.S. Congress. And then at the state level, essentially the governors would have been appointed by the president, right? So the governors of each state would have been sort of a federal appointee, and they would have had the ability to preempt state legislation, right? So the sort of federally appointed governor of a state could be looking at the state legislature, and we have a state lawmaker here, so I'm dying to know your views on this, but so a federally appointed governor who's keeping an eye on what the state legislature is doing, and then could tell the state legislature, I'm going to veto that. And so just, don't cross that line. And in Hamilton's mind, this was necessary for unity, it was necessary to kind of protect the country. And he actually thought it was a nicer way of doing it than waiting until the law was passed. So again, we don't have anything even remotely close to that. So what do we end up with? We end up with a system that really reflects this kind of unique genius that Oliver Ellsworth brought to the Philadelphia Convention. So just a quick word on this. The real issue that divided the delegates in essentially the first 6 weeks of the Philadelphia Convention. They get there sort of in the middle part of May of 1787, and then the famous Connecticut Compromise is a great place to talk about it, is sort of made official around the second week of July in 1787. So the first, essentially 6 weeks of the convention is all about how to apportion the National Congress, right? And this is where we get the Connecticut Compromise. So the House is apportioned by population, and then the Senate, there's equal state vote in the Senate. And that debate of how to sort of apportion, how to sort of come up, how to represent the people in the National Congress, in the federal Congress, that was really the first 6 weeks of the convention. So let me just make this point very clear. They're not debating during that time what powers the federal Congress is going to have. They're debating how to make up the federal Congress, right? They sort of realize that is actually sort of a debate we need to have first, right? Like before we talk about, what kind of keys we're going to hand over, let's talk about who we're going to hand the keys to. That was sort of the sequencing of it, okay? So that was the context, very, very, very big debate. And, it had proponents on both sides, real heavyweights on both sides. So on the view that the Senate and the House should both be proportioned by population, I'll quote from James Wilson, who said, "Can we forget for whom we are forming a government? Is it for men or for imaginary beings called states?" So the opposition, or the proponents, I should say, of popular apportionment of both houses, had a view that this was about legitimacy, right? This was about the legitimacy of this new lawmaking body. If it's not representative, then how can it be legitimate? How can we trust anything that comes out of it? Again, the idea being, let's not talk about what it can do, let's talk about how to make it up, and then we'll decide whether that's legitimate or not. So that was a very forceful argument coming from the opponent. So it was Ellsworth. Roger Sherman proposed the idea, but in terms of the speaking at the convention, it was really Ellsworth who stood up and essentially went toe-to-toe with Wilson, with Madison and others, and kind of led the charge. And so I'll just, again, briefly lay out what Ellsworth said. He made sort of two arguments, I think, against Wilson and others. One was sort of theoretical, and the other was very practical. So on the theoretical side, to sort of respond to Wilson, right? Wilson is saying, okay, well, what does this government represent? People or imaginary beings. I think Ellsworth's view was, no, it represents people. But if you look at the people of the United States, they have allegiances to the whole country and to their state, right? This is part of the American soul. It's part of the American fabric, right? So to be truly representative of the American people is to recognize this dual affiliation, right? So that was sort of the theoretical response. And then he had a series of just very practical responses. So one of his practical points is that, if we look at large republics, right, like, governments that are trying to govern a large territory, it's very difficult. It's very hard. It's a big risk. And so he was seeing the equal state vote as a way of kind of breaking up this larger republic, not to divide the parts, but in a way where each unit could be separately governed in a very professional, competent, and efficient way. And that would make it easier for the general government to sort of stay within its lane and to be competent in its area. The other points that Ellsworth made was really, look, why are we here in the first place, right? Like, if we risk everything, because, we didn't have, in the Articles of Confederation in our previous government, we had a Confederation Congress where the states were represented equally. We didn't have a popularly apportioned legislature. To have a fully popular apportioned legislature was kind of go from 0 to 60, right? And so Ellsworth's view was, let's not overcorrect the issues that the problems that have sort of come up. And so he said, let not too much be attempted by which all may be lost. In other words, if we go too far to the extreme, we won't have an agreement that we can all get behind. He said something else too. It's a great imagery that he used. He said, we don't need to raise the foundations. We need to fix the roof, right? I mean, it's like a very good litigator, like a nice sort of pithy phrase, right? Like, raising the foundations is coming up with a brand new system of government for the United States at a period of crisis in 1787, really tough time in our country's history. And if you think about what Hamilton is suggesting, a president for life, a Senate for life, a Congress that can pass any law, if you think about what the Virginians are suggesting, right? These are very different forms of government for an American people who, yes, the federal government was in a very difficult time. By the same token, the state of Connecticut, the state of Virginia, these are political communities that had almost a 200-year history by the time we get to 1787. So there's a real foundation there. And he's sort of saying, let's not raise the foundation. Let's fix the things that need to be fixed. He ends up succeeding. He does some nice legislative maneuvers in the Philadelphia Convention, and he ends up getting his way. And James Madison says of Ellsworth, his reasoning was clear and concise. He wins the day. He goes on in the ratification period. He continues the charge, right? So the Constitution is framed by the framers in Philadelphia, but it's also to be ratified, and that's a state-by-state basis. If it doesn't get ratified, it's sort of a non-event, and we're back to square one, almost a failed state, I think you could say, for the U.S. government. So it gets ratified. Ellsworth leads the charge on ratification. And that, during the ratification debate here in Connecticut, and he's very successful. Connecticut ratifies very early on. The vote is 128 to 40. And Ellsworth really talks about the judicial branch as a key feature of the Constitution. And so I'm just going to read a sentence here from the ratification debate in Connecticut. If the general legislature should at any time, that's the Congress, overleap their limits, the judicial branch is a constitutional check. Right? I mean, just very clear, about the system that we have. If the United States goes beyond their powers, it is void. And the judicial power, the national judges, will declare it to be void. On the other hand, if the states go beyond their limits, the law is void, and upright independent judges will declare it so. Okay, so he sees the judiciary, right, not as being federal, not as being state in terms of how they're going to judge cases, but as being impartial, keeping each side within its boundaries. And then again, he says, I always love the imagery that he uses. He's a good practical attorney. He says, the road is broad enough, right? So he kind of describing kind of the American political experiment as a road with two lanes and maybe a line down the middle of it. The road is broad enough, but if two men will jostle each other, the fault is not of the road, right? It's, these two passengers are angling towards each other rather than using the breadth of the road that they have. I'll just say one other really brief thing on the framing, which is, if we think about the judicial branch as a constitutional check, there's a famous line from the Federalist Papers about the judiciary as the least dangerous branch. So Alexander Bickel, who taught at the Yale Law, he was the dean of the Yale Law School back in the 1960s. He passed away very young, but he wrote a well-known book about kind of constitutional theory and history called The Least Dangerous Branch, and he's quoting Federalist 78. And there's an interesting sort of reflection on this, that for Ellsworth, the judicial branch was the right constitutional check, right? Versus, again, what Hamilton wanted which was like the president appoints governors who can just veto state law, or what the Virginians were talking about, that there's going to be a national legislative power to veto state laws, right? He thought that the judicial check, again, it was more balanced, it was more impartial, it wasn't as direct and as forceful. And there's a sense, if you look at the Federalist Papers closely, that Hamilton was actually regretful that we didn't have a more dangerous check on what he considered to be excessive state power. Because he goes on in Federalist 80, and he says in Federalist 80, there was an idea that there would be either a, quote, direct negative on the state laws, like a direct ability to sort of veto state laws, or an authority in the federal courts. The latter, so the judicial check, this is Alexander Hamilton writing, appears to have been thought by the convention preferable to the former. In other words, like, this is what they came up with. I'm just reporting what they where they settled, rather than what Hamilton might have wanted, which is again this much more direct check. But again, Ellsworth, always thinking practical, don't overstep bounds, find something that will work. This continues. Just briefly, I'll talk about his chief legislative achievement, which is the Judiciary Act of 1789. He's in the first U.S. Senate, and he gets to work on the Judiciary Act. So why do we need a Judiciary Act? So basically, if you look at the Constitution, the judicial branch is laid out in Article 3. And what the framers did in Article 3 is they established one Supreme Court. So the U.S. Supreme Court is established in the Constitution. And then such inferior courts, right? So those are like the federal district. I hope there's no federal judges here. The language inferior is in the Constitution. So these are not my words. So in any case, the federal district courts and what we now call federal circuit courts, we'll talk about them for a second, those were not established by the Constitution. What the constitutional text says is they shall be ordained as Congress shall from time to time see fit, right? So basically, the Congress would have to pass legislation if we were going to have federal district courts, federal appeals courts, right? So what would have happened if the Congress didn't pass any legislation? What would have happened was the only way to get to the U.S. Supreme Court would have been you would have gone through the state court system. Okay, so like if you had a case and you're seeking to assert your rights, you'd go through the state process, so state trial court, state appellate court, the state Supreme Court, and then you would appeal to the U.S. Supreme Court. And at that point, you could get a hearing from a federal court, right? So that would have been the process to sort of vindicate federal rights. If the Congress just said, hey, you know what, I know we have the power to do that, but there are more important things to do, we'll get to that when we get to it. We really just would have had the Supreme Court kind of overseeing state litigation. But how many cases are really going to go through that whole process, right? I mean, I think we all know at a certain point people get tired of talking to lawyers and they don't want to litigate maybe on and on and on. So Ellsworth, felt like, okay, we need to do something different. We need to actually establish these federal trial courts and the federal appeals courts. So what was the challenge here, right? I mean, again, we think back to, this great compromise, the Connecticut Compromise, right? And you've got these two sides. We want to represent all the people, and then also you've got the Ellsworth side. We have to come up with a plan that works. So what was the debate over setting up federal courts, right? I'll just briefly sketch this out. So what federal courts do are sort of two things. One is if there's a federal law, so if Congress passes a law, these federal courts will hear cases where parties are trying to enforce a law or trying to say, no, the law is not being properly enforced. That part of what the federal courts were going to do was not controversial. So even so-called anti-federalists who weren't wild about the Constitution, they were okay with that. These are federal laws and they can be enforced in federal court. Fine. The real controversy was over something called diversity jurisdiction. Does anyone know what any lawyers in the okay, go ahead. What do you?
Citizens from two different states or different states involved in it.
Yes, absolutely. Or a citizen from one state and a citizen or subject of another country. Okay, so yeah, you nailed it. So this is great. So the federal courts also have jurisdiction over cases between a citizen of Connecticut against a citizen of Virginia, or a citizen of Virginia against a subject of Great Britain, or two different states, right? That type of thing. And let me just like highlight, this was really controversial. Okay, this was like a really big deal. And I'll just say why for just like, I'll just give two reasons as to why this was like a really, really, really big deal. I think maybe the place to start is just to sort of think about the war, right? The war goes until 1781, 1783 it starts, sort of 1775, so it's a long war. I think we're sort of familiar now with long wars. This was our first long war. And the latter part of the war, obviously the war starts up here in the Northeast, but the latter part of the war is fought where, right? In the South, yeah, very bloody, very really difficult fighting in the South. And the Southern economy was a much more agricultural economy. Many Southern planters, many Southerners were in debt to British creditors. Okay, that's sort of how the economy worked. After the war ends, the British creditors felt like their debt still needed to be paid, right? A deal's a deal. Yes, there was a war. However, a debt's a debt, and these debts need to be repaid. And so British creditors started to assert their rights as creditors and try to get paid back for the debts that they were owed by typically Southern Americans. So in Virginia, North Carolina, South Carolina, this was a big deal. You can imagine the way the people in those communities felt about these lawsuits, right? They were not popular lawsuits. I mean, they had literally just been fighting a war, like a guerrilla war in their area. And now, the side that lost is trying to collect money from the side that won. So it was very controversial, right? And in the 1780s, in the mid-1780s, the British creditors, who at the time there's no federal courts, right? That doesn't come until the Constitution, Judiciary Act. So they would bring these lawsuits in like state court in Virginia or North Carolina, and juries would not agree with them. Judges wouldn't agree with them. Now, maybe that sounds all well and good, but the concern from the American framers were like, hey, if the British creditors don't get paid, at some point they're just going to reinvade our country. They're not just going to take this sitting down. At some point, this is going to cause problems for the entire United States of America. So we felt, even though, you can say what you will about each of these individual cases, that we needed to have a better way of adjudicating these cases. So what was controversial about federal courts is that by allowing so-called diversity jurisdiction, they were giving British creditors a federal court to go to assert their contractual rights. Okay, so diversity jurisdiction is about the parties. The underlying law is not federal law. It's a contract, it's property, it's what's typically handled in state court. But because of the parties, the nature of the parties, you get this new venue, right? And so this was really a very tough, sort of political ball of wax to deal with, if you're Oliver Ellsworth, right? At the one hand, if you just say, hey, too bad, so sad to the British creditors, it would risk war, right? Also, how many people are going to want to do deals with, what is this going to do to American capital markets, American finance? That was sort of Hamilton's point. On the other hand, if you allow every British creditor to bring every American debtor into federal court, there's certain questions about legitimacy. I think there was one Virginian, I quote him in the book, who said, why did we even fight the Revolutionary War if we're going to lose in court over these cases? So you can see, I won't belabor the point. So what Ellsworth did in the Judiciary Act was he set up federal trial courts. He set up these circuit courts, and I'll talk about that in a second. But what he did on diversity jurisdiction was he had a money limit that he put in, right? So he put like an amount of controversy requirement. So not any contracts case, not any creditor-debtor case could get into federal court. He made the amount high enough that about 90% of debt creditor issues had to remain in state court. So basically what Ellsworth was doing was only the big ones. The big money cases, those are probably the ones that could cause a war or some kind of international conflict. those are the ones that can really rattle international credit markets, finance markets. So we're going to make a compromise. If it's a big credit case, you can go to federal court. If it's a small one, we're going to keep those in state court. That was basically the compromise of the Judiciary Act. So again, really, a difficult situation. Again, it was Ellsworth's sort of practical spirit that kind of got us through it. Just one last thing I'll say on the circuit courts. This is also kind of a fun thing. Does anyone know why they were called circuit courts? They're still called this to this day. Do you know why?
Or the circuit.
Yeah. So the circuit courts, right? So there was basically a circuit, and the judges would ride around the circuit to go to these different cases. And now, I mean, if we think about like the way the system is set up now, you've got individual federal trial court judges, and then you've got the circuit courts of appeals that have a different crew of people on there, and then you've got the 9 that are on the U.S. Supreme Court. In Ellsworth's Judiciary Act, the circuit courts were made up of 2 Supreme Court justices and then the local district court judge. So it was a way to economize. This was like the startup phase of the U.S. government. So it was, again, a sort of a political thing because a separate opposition to this judicial branch, apart from the creditor cases, where we don't want to spend a ton of money creating all these different federal judges. So Ellsworth's view was, okay, here's what we'll do. We'll sort of dual hat the Supreme Court justices, and we'll make them ride circuit around the different parts of the country. And that way, and they're going to team up with the local federal trial court judge. That'll give 3, and that'll be the circuit. So that's how they did it. I'll just say one last thing here on Ellsworth as a judge. So we covered kind of Ellsworth as a framer, Ellsworth as a lawmaker, and then Ellsworth as a judge. So in 1796, there's a vacancy on the U.S. Supreme Court. Different dynamic back then. It was actually really hard for George Washington to find someone who was willing to serve on the U.S. Supreme Court as Chief Justice. I think this is speculation on my part, but I think it may have had to do with riding circuit, right? Like riding circuit, it didn't mean like, flying down to Atlanta to hear a case. Like it meant riding the circuit, and the conditions with just different heat-related issues and a whole range of things, made that a very difficult ask to get someone to do. At the same time, we had sort of this history in the early part of our country of the Chief Justice, kind of serving in diplomatic roles as well. So that might have been part of the hesitancy, that you're not just going to be a judge, you may have to go do an overseas mission. John Jay did that. Oliver Ellsworth ended up doing that after he took the job. So anyway, so Washington went through a number of different people, John Rutledge, Patrick Henry. There was a sitting justice that he went to, and finally he went to Oliver Ellsworth. And I think it's pretty clear, the reason why Ellsworth wasn't the top choice was he was so effective for Washington in the Senate. The Judiciary Act and other pieces of legislation were really, I think a good example of this sort of style of government that Washington was very comfortable with, which was having federal power but not overstepping the federal government's bounds. So they were very simpatico. Nonetheless, the country needed a Chief Justice. Oliver Ellsworth got the job. One of the first things he did was the House of Representatives. This is right after Ellsworth was appointed as Chief Justice. The House of Representatives were demanding the diplomatic instructions that Washington gave to John Jay related to a treaty. And Ellsworth just kind of put that one down, very emphatically, and essentially said, look, the negotiations that we have with other countries is the executive that is trying to come up with these negotiations, and so the legislature, obviously through the Senate, has the power to ratify treaties, but it doesn't have the power to sort of be micromanaging the process in this particular way. Interestingly, that wasn't a case. Ellsworth just essentially wrote an opinion. The formalization of the kind of case and controversy requirement and the courts only speak through opinions, that wasn't quite sort of set then. So Ellsworth just essentially fired off this missive, but that put a rest to that. The other thing he did, and I'll finish with this, is there was a really controversial piece of legislation in 1798 called the Sedition Act. So there was the Alien and Sedition Act, or Alien and Sedition Acts. And The Sedition Act, as the name implies, was an act that was really targeting, political opposition to the Adams administration. So obviously, it was a controversial piece of legislation, remains such to this day. And Ellsworth was a judge, and he was Chief Justice of the U.S. But as I mentioned, the justices were much more in circulation in terms of these circuit court cases and other cases that they were handling. And the judges would oftentimes give these grand jury instructions. And if anyone's ever been on a grand jury, been on jury, jury instructions are a very kind of common practice now in American law. Back then, in the 1790s, particularly if it was like a U.S. Supreme Court justice, the jury instructions would be, really forceful ways of kind of like getting people's attention. And so there was actually an American justice who, there was an impeachment trial over this U.S. justice, really as a result of a jury instruction that he gave. And so it was a really kind of like tightly watched part of American law. Jury instructions from Supreme Court justice would be like republished in newspapers and so on. So the Sedition Act, the reason why there were jury instructions over the Sedition Act was the government was prosecuting people for violating the Sedition Act. So Ellsworth had to give a jury instruction in a Sedition Act prosecution. And again, just think about the balance, think about the practicality here. He told the grand jury that conduct that was manifestly subversive to the national government was problematic. However, he also told the grand jury that their obligation to obey a federal law lasted only until lawmakers, quote, overleaped the Constitution, right? So again, the balance. And after he gave that jury instruction, and again, as I mentioned, jury instruction was very controversial at the time. There was a justice that went to an impeachment trial in the Congress over it. Even a hostile newspaper, the Democratic Republican Virginia Argus, which was no friend of the Sedition Act or the Federalists who passed it, admitted that Ellsworth's charge proved him to be a man superior to most of his brethren because he avoided the passionate and indecent invectives that others had practiced. So that sort of rounds out, I think, the kind of key aspects of Ellsworth's life. He did a diplomatic mission, a very difficult one, to France. We were on the verge of war. He retired from his post as Chief Justice at the conclusion of the diplomatic mission while still in France. And he came back to Connecticut, wrote an agricultural column in the newspaper, continued to serve in state government. He was someone, and I'll finish with this, who didn't just describe the constitutional order, he built it. First in Philadelphia, then in the Senate, and then finally as a Chief Justice. So John Marshall may be our great expositor of the Constitution, James Madison, a great theorist, but Oliver Ellsworth, in my view, was the Constitution's great builder. Thank you very much. And I'm happy to take any and all questions. Yeah. Go ahead.
John Marshall was the Chief Justice that ruled on the principle of judicial review, that the court could declare unconstitutional acts of Congress. Did Oliver Ellsworth believe in that and feel that it was self-evident in the Constitution? Because he never spelled it out when he was a Supreme Court justice, did he?
Yes, it's such a great question. My take on that is Oliver Ellsworth definitely spelled it out. In the landholder essays, he says that the judicial branch is the constitutional check. And so I think he really anticipated Marbury against Madison. And if I could fault Marbury against Madison in one way, it's that John Marshall didn't cite the landholder essays, right? I mean, I think, the opinion could have been that much more forceful if he looked at a leading American who was a framer of the Constitution, Oliver Ellsworth, who was very influential in the Philadelphia debate, right, in the convention, who then writes an essay. It's not the Federalist Papers, right? But it's in Connecticut. It's successful there. So I think that's where Ellsworth spelled it out. You are correct that in the few years that Ellsworth was on the court, he didn't have a case like Marbury against Madison, where that issue was sort of like precisely presented to the court. Now, ironically, the case that went before John Marshall, Marbury against Madison, dealt with one provision from the Judiciary Act. And so the Judiciary Act, the main thing that it did was kind of what I talked about, setting up federal trial courts, setting up the circuit court system, this really elegant balance with the amount of controversy rule, all of that. And kind of the three-tiered system that we have for federal court, that exists to this day. I mean, like I said earlier, this is a rare achievement of a congressional statute that is still working, living, breathing, influential 200 and some years later. The part of the Judiciary Act of 1789 that was declared unconstitutional in Marbury against Madison was a particular provision that had to do with the original jurisdiction of the Supreme Court. So again, I don't want to minimize the importance of that provision. Certainly, anyone who's represented parties in a case, it's always very important to the parties how the case goes. But in the grander scheme of things, from kind of an American sort of political order, it was not the main element of the Judiciary Act. I often wondered how Ellsworth would have come out in the case. I mean, it was his own legislation. I think he still would have rendered an opinion. I think he would have taken the view that the Judiciary Act came from the legislature and judges can review it. But in any case, counterfactual, so we won't know. Other questions? Oh, yes, sir.
Can you talk a little bit about Ellsworth's argumentation around the Three-Fifths Compromise?
Yeah.
And perhaps touch on some of the cases that came before his court.
Yeah, sure. I'll just say a little bit on Three-Fifths. This is obviously this is a difficult aspect of American history. Human slavery is a part of the American colonies. It's a part of the Southern colonies in a very serious way. And so, when you look at the large state, small state debate, the large state numbers, right? The states with large populations. Okay, so Virginia is an example. That includes the free population and the enslaved population. Okay, so just think about that for a second, right? Connecticut was fast on the way to abolition. Other northern states were fast on the way to abolition or had a much lower enslaved population. Okay, so that was a point that Ellsworth made. The Three-Fifths Compromise, again, these things, these are difficult conversations to have. So to say that an enslaved person is counted as 3/5, obviously that sounds really terrible. I think we can all agree on that just by the way I'm articulating it. But if you look at the alternative to counting an enslaved person as 3/5, if you count an enslaved person as a full person for representation purposes, you're giving the slave states more representatives based on the fact that they have more slaves, right? So if a state has 700,000 people and 500,000 of them are enslaved, if you count all 700,000, they're going to get a lot of representatives, even though 500,000 of their people are not there on their own choice, right? They're enslaved. They're not going to vote. They can't own property. You can go down the whole list of things. So 3/5, there were arguments in the Constitutional Convention that we shouldn't apportion any representatives based on enslaved population. So that was some of, I think, Ellsworth, the force of his argument about the equal state vote, that the states weren't really equally situated in the sense if you wanted to judge them on population. Their boundaries were drawn by British charters, and they got different pieces of land, which affects how many people live there. There's slavery in some and not others. It was a complex time where there's a lot of different things going on. But I think, Ellsworth's view, again, was we need to keep this country together, and we're not going to keep it together without making difficult, though practical, compromises.
And some of the cases that he addressed?
I'll probably will have to get back to you on the. I have a recollection of a particular case on slavery, but I'll have to get back to you on that. Yeah, go ahead.
Yeah, I remember looking back at some early decisions sometime historian who's been to his reign, but I remember looking at when he was the Chief Justice and thinking about judicial integrity because it appeared that he recused himself from a case because Connecticut, his home state, not because he had any personal interest, but Connecticut was a part of it.
Right.
I don't know if you ever ran into that.
Yeah.
It was you wouldn't have that today, you know.
Right.
But that was one of the bases where he recused himself from the decision because the Connecticut was a part of it.
Yeah, no, I mean, as I said before, this was a startup phase of the American government. So there were definitely a number of things that happened where, like I think our first Attorney General was like still in private practice when he was serving as Attorney General of the United States. Like it was sort of like he had other things going on. So it was a different time. But I don't mean to demean the founders by any stretch of the imagination. Like in terms of, I think, the sort of big picture moves that they did, they really did have a very deep sense of, what needed to be done. There's a American constitutional historian, and some of this touches, on your question, who says, like, if you look at the American form of government, if you look at what came from Philadelphia, there's no form of government that better matches human nature as it is. Right? And I think that's a fair assessment. And again, people aren't perfect. Certainly people at the time weren't perfect. They had their blind spots in very serious ways. Yet, the country was really in a difficult position. And I think but for some of these practical judgments, we wouldn't be here celebrating, 250 years of independence. Yes, yeah, Carrie.
In your book, you make a reference that because of Ellsworth's upbringing here in Connecticut, in Windsor, and his congregationalist upbringing, that had an influence on how he saw the role of government and how people's relationship to government kind of reflected the role of how the church government rules itself,
Yeah.
and the relationship to people and as the governed. And I wanted to hear your opinion because that kind of goes against the Enlightenment principles that he would be interacting with both Hamilton and Madison and others. So you kind of have these two different philosophical theories kind of interplaying together in the constitutional convention there. These two dichotomies.
Yes, that's such a great question. And no, I think Carrie's right to sort of, the way Carrie puts the dichotomy is sort of, you've got kind of the Enlightenment view on one side, and then you've got, the sort of, the view that's a more religious or more based on experience, more based on practicality, and that's definitely, where Ellsworth falls. And, I talked a lot in the speech about the practicality, but another way of looking at it is just sort of, understanding, how human beings sort of operate, how they flourish. And so I think there's a certain religious influence. So if we think about Ellsworth, the kind of congregationalist mentality, right, which is very much of a mentality of, you think about what the local community is looking for, the kinds of spiritual help that they're looking for. You think about, representing, individuals kind of where they are and sort of working kind of almost in a bottoms up kind of way, rather than other religious institutions that took more of a top down, kind of approach, an international approach, that however it may be. And I think that does really influence Ellsworth in terms of, having a vision of the Constitution that really, I don't want to say privileged local government, but definitely made a place for it, right? And I kind of see in his appreciation for his religious upbringing a kind of a sense of that. And I think there's also a sense that, human beings are fallible. We don't always see things as clearly as we should, right? And I think that comes from his religious upbringing, his religious convictions. And that's very different from an Enlightenment view, which is going to be a lot more theoretical, right? It's going to sort of look at human beings in the abstract rather than human beings kind of in the real world. I will say on Hamilton, this is sort of the anniversary of his duel with Alexander Hamilton. I was trying to think, I think it was either July 10th or July 11th. I forget which day it was, but we're right up on an anniversary. He did ask for communion after he was shot, Alexander Hamilton, so he had kind of a return to the faith as his life went on. Jefferson, definitely an Enlightenment figure. But again, with Ellsworth, it's I think much more of a kind of a practical bottoms up, what I've seen work kind of view, and he's able to kind of get those points over the finish line. Yes, sir. Oh, and I'll get to you next, ma'am. Yeah, go ahead.
I've heard the phrase used before the Civil War was these United States, and after the Civil War, the United States.
Yeah.
Where do you think Oliver Ellsworth would have fallen on that description?
He definitely saw a role. I mean, I think he was more supportive of federal power than like Roger Sherman was. And so if you look at all of the votes in the Constitutional Convention, obviously he was a forceful and a successful advocate for the equal state vote in the Senate. That debate is settled in July. We then go into kind of the substantive parts of the Constitution, the power to tax, the various substantive federal powers, and he's willing to give the federal government those powers. He also does something, and maybe this is the best response to your question. One of his other contributions, Oliver Ellsworth, is near the end of the constitutional debate, he inserted the word federal into the Constitution versus United States. And so, he had kind of this idea that there was a federal government, right? Federal didn't mean national. I'm sorry, he substituted federal for national. So to call him a nationalist is probably to go too far, but he was definitely a federalist, which is to say that there is a level of government that represents the entire United States that's legitimate. Yes, ma'am.
I don't have heard this. The founders were more faith-based on how they made decisions, personal experience.
Yeah.
How did they foresee a state not having dual representation in legislation?
You said more faith-based, and then
The
dual.
founders were more faith-based on their decision-making, their background.
Sure.
their faith
Yeah.
behind that.
And then what about the dual when you say dual?
Like Connecticut, we only have one form of representation in the Senate and the Congress.
Right.
Did they foresee that?
Yeah, I mean, I guess, okay, so, when I think about the founders' kind of religious views, I sort of see that kind of in one area. The dual representation point, I think, around Ellsworth is kind of like you're both represented at the state level and then also at the federal level, right? So, you have like two sovereigns, so to speak, in a secular sense, right? Obviously, this is outside the scope of like religious authority, but you've got like two separate sovereigns, the state sovereign over local issues, and then you've got, the federal sovereign that's kind of taking the interest of the entire, republic to account. I think for Ellsworth, I think the faith-based aspect of all of this was, because of the sort of local religiosity, right, and the connection with the Congregationalist faith, I don't think he would have ever contemplated like just a purely national government, right? I mean, that is so contrary, I think, and again, I'm not making value judgments here, but just historically speaking, that is so contrary to the vision of a local religious community that's electing its leaders, that's sort of trying to kind of get through life together, and advance spiritually. So, you don't ever see him sort of contemplate the types of things, and I'm not harping on Alexander Hamilton, but like a federal government that can pass any law, and is just like in charge and can write on a blank slate. Like, I think for Ellsworth, that was giving up way too much. And I think one of the reasons why he had real local attachments is the faith-based aspect. Any more?
Right.
All right.
What question? Have you been to this marker in the cemetery?
This is my second time here, but I have not been, so hopefully today I'll do that. Yeah, let's do it.
All right.
Thank you, Michael. Michael, if you don't mind standing up here for a second, Michael, stick around. We do have something to present to you. To thank you for coming away from Texas.
Oh my goodness, thank you.
Some mementos from the homestead. You can't get them anywhere else.
And what made some of those be, Janet?
Oh, we have to sort of reveal them. Well, there's this
it
is actually not Christmas wrapping.
Okay.
It is a print that the chapter commissioned a while back. So it's a It's a custom design print and signed and numbered. And then we have a very cute little, I'm going to say a statuette of the Oliver Ellsworth Homestead from the Historical Society, and a Christmas tree ornament, which you,
Oh, thank you.
can hang on your tree of the homestead as well. So we thank you for coming, and it's a long way up here, but thank you.
Thank you. It was my pleasure. Thank you so much. Yeah.
So I did want to end this event by the way Michael ended his book here. And inside the home, there was a statement from Ellsworth near the end of his life. I have visited several countries, and I like my own the best. I've been in all of the states of the Union, and Connecticut is best. I've been in all this, I already said that. Windsor is the pleasantest town in the state of Connecticut, and I have the pleasantest place in the town of Windsor. I am content, perfectly content, to die on the banks of the Connecticut. Pretty cool. Thanks everyone for coming. There's tons of baked goods. Thank you to the Regents and all of the baking, and there's going to be tours of the homestead. So if you have some more time, if you've never been, please go visit the homestead. Thanks everyone.